Good afternoon.
Good afternoon.
Good afternoon.
Thank you.
Good afternoon.
Thank you, everyone. I am Judge Betty Rankin Widgeon, the appointed master for this matter. And today we are getting started on, I believe this is day 6 of the hearing. Counsel, are we ready to begin this by calling the first witness for today from disciplinary counsel?
Yes, Your Honor.
All right, thank you. And from the respondent.
Yes, Judge, we're ready to proceed. Thank you.
All right. And who is your first witness?
Judge Tracy Green.
Thank you. Judge Green, I am going to swear you in. I'll be using the usual oath and then asking you with respect to the sequestration order and the order regarding the hearing and witness protocol. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
Thank you. And state your name.
Tracy Green.
All right, thank you. We have the spelling of your name, Judge Green. The sequestration order reads as follows. Witnesses who may be called are subject to this sequestration order. The order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from doing any of the following: discussing her testimony in any format or by any means with another witness, viewing proceedings on any device, listening to the proceedings on any device, or accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to discovery of the failure or violation. With respect to the order regarding hearing and witness protocol. Counsel, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Judge Green, are you alone in the room at this time?
Yes, Your Honor.
Thank you. No witness shall have access or review any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. If a witness needs to refer to a document, she may do so only if invited to by counsel or approved by the master. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you certify that, Judge Green?
I do.
Witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during their examination other than the device they will use for their virtual testimony. So Judge Green, I've read these 2 orders, and do you certify and affirm that you have abided by these orders and will continue to do so during the pendency of this trial?
Your Honor, I have abided by the orders, but I was using my phone a moment ago and it's across the room now. I can take it out of the room though. It will just take me a moment.
Just so it's not within your reach right now?
It's not within my reach.
All right, then that's fine. Anything further before we begin with the examination of this witness from either side?
No.
No, Judge.
All right, thank you. You may begin. Ms. Weingarten, you're going to start the examination.
Good afternoon, Judge Green.
Good afternoon, Ms. Weingart.
Judge, did you sign an answer to the complaint on December 31st of 2020?
I'm
Um,
so sorry, you went out. I didn't hear the question.
I was going to say, Ms. Weingarten, for some reason, your microphone is a little bit spotty. So I'm not sure if something can be brought closer or just what. Usually it's fine, but now it was a little spotty.
I am
I
going
raised-
to go donate my headset to her and see if that makes a difference.
All right, we'll pause for a moment then. Thank you.
I've never used one of these.
Into the US court. Computer should automatically adjust to it. Turn it around.
Judge, can you hear me now?
Yes,
Yes.
sounds good.
Okay,
All right, so you'll have to ask that first question again, please.
okay. Judge Green, did you sign a complaint dated December, the answer to a complaint dated December 31st of 2020?
Yes,
And did you do so under penalty of perjury?
yes,
Is it accurate that your answer to the complaint claims that you told CPS, and I want to read an answer to you. Judge Green admits that she was aware her son had, on a single occasion, slapped Gary Jr. across the face hard enough to leave a handprint. Judge Green advised Child Protective Services of this fact and that she applied some foundation to the cheek of Gary Jr. during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence of child abuse or making a false statement about her knowledge. Did you write
Your
that in
Honor,
I'm
Your
sorry,
Honor,
go
can we
ahead.
just get a reference to the paragraph number for the sake of the record?
Yes, that was paragraph answer 10F, like Frank, on page 5.
Thank you.
Did you answer that way, Judge?
yes,
And did you repeat that answer or a form of that answer 4 other times in the answer to the complaint?
I believe so.
To whom at CPS did you make that statement?
If I made that statement, it would have been to Ms. Leslie Apple.
When you say if I made that statement, are you uncertain about whether you made that statement?
Well, I'm uncertain as to whether I made part of the statement.
Would you agree that in your answer to the complaint, the paragraph I just read, that is a correct recitation of what paragraph 10F says?
Yes,
Okay, we're going to move on then to another portion of your answer to the complaint. This is answer to number 22. And I'm referring to the bottom of page 13 and the top of page 14. Or I'm sorry, the top of page 14. Did you write, Judge Green advised Child Protective Services of the slapping incident and that she applied some foundation to the cheek of Gary Jr. during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence of child abuse or making a false statement about her knowledge? Did you write that in your answer to number 22?
I'm not certain about the number, but that was my answer.
Okay. I am now referring to your answer in number 23. And I'm referring to page 16. Did you answer in the complaint, Judge Green advised Child Protective Services of the slapping incident and that she applied some foundation to the cheek of Gary during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence of child abuse or making a false statement about her knowledge? Did you answer that?
Yes.
Now I'm referring to to complaint paragraph 24, and this is on page 17, and I'm going to ask you if you answered this. Did you say Judge Green advised Child Protective Services of the slapping incident and that she applied some foundation to the cheek of Gary during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence of child abuse or making a false statement about her knowledge? Did you answer that?
Yes.
And finally, I'm referring to answer paragraph 26. This is on page 25. Did you answer Judge Green advised Child Protective Services of the slapping incident and that she applied some foundation to the cheek of Gary Jr. during a CPS interview, clearly demonstrating that she was not attempting to cover up alleged evidence of child abuse or making a false statement about her knowledge? Did you answer that?
Yes.
So would you agree that you answered that same answer 5 different times in the answer to your complaint?
Yes.
Now, a moment ago, you told us that you might have said some of it. Is that what you said?
I don't remember exactly what I said, but I think I said if I made that statement, I made it to Ms. Apple.
Why is it that you don't know if you made that statement?
Well, there are a number of reasons why. The first being that I wasn't unsure about whether I made the statement until it became very clear in these proceedings that I was being accused of not being truthful in making the statement that was in my complaint, the statements, I should say, that were in my complaint. After I realized that, I began to consider my memory about it. I began to try to recollect what exactly happened when I spoke with Ms. Apple.
When you wrote the complaint and signed it under penalty of perjury, you were certain that it was accurate, correct?
I was certain that it was accurate, but I should not have been certain that it was accurate.
Besides to Miss Apple, did you make that statement to anyone else?
May I ask a clarifying question, please?
Well, let me
In
rephrase the question. If you said it to Miss Apple, did you also say it to anybody else?
Well, that's just it, Ms. Weingarten. When you're referring to the statement and it, and the part that I'm having challenges with is whether I told Ms. Apple about the makeup. So I can't really say that the whole statement is something that I said if I'm not certain if part of it is what I said.
What part of it did you say?
I'm certain that I told her about the handprint, about the slapping incident and the handprint.
Besides making that statement to Miss Apple, would you have made that statement to anybody else?
Do you mean as a part of the investigation into the
Are we breaking up?
No, but you're both talking at the same time. So when Judge Green said, do you mean as a part of the investigation? I think you said something else and they collided.
Okay. Judge Green, I didn't mean to interrupt you. Go ahead.
I'm sorry, can you ask the question again?
If you said that statement, did you say it to anyone besides Miss Apple?
Referring to the handprint and the slapping incident only?
and the makeup.
No,
So if you said it, Miss Apple was the only person you would have said it to.
if I told anyone about the makeup other than Miss Apple, it would not have been anyone other than my friends and my husband.
Now, did you know Miss Apple before her investigation in this case?
No,
Did you work with her when you were a protective services worker?
I was never a protective services worker, so no.
Did you ever have her as a witness on any case you represented children or parents on as a lawyer?
I don't believe so.
Had you ever met her up until her investigation in this case?
I don't believe so.
Now, you talked to Miss Apple multiple times during this investigation, didn't you?
Well, I specifically remember 2 times when I spoke to her outside of a family team meeting. I was involved in both family team meetings, so we had communication at those times. But actually just speaking to her alone about allegations would have only been 2 times that I can recall.
Did you see her at your son's house on June 24th, 2018, the day the children were removed?
Yes,
Did you talk to her that day?
yes, yes,
Did you see her at the family team meeting that was held on June 26th of 2018?
yes,
And did you talk to her that day?
yes. I talked.
Did you and she have a phone call on June 26th of 2018 after the family team meeting on June 26th of 2018?
I'm not certain about the date of our phone call. I should say phone calls.
Did you have a conversation with her by phone after the family team meeting?
Yes,
Did you have a phone call with her a few days after the family team meeting?
I don't remember another phone call a few days after the family team meeting, other than the first one that I had after the family team.
Did you respond to a phone message Miss Apple left for you when you were out of town and call her back on or about August 9th of 2018?
Yes,
Did you have any other conversations with Miss Apple besides the ones I've discussed?
yes.
When were those conversations?
I don't know when, and I can only think of one at the moment, but it would have been let's see. I think that it was before the juvenile court trial began, but I don't know the exact date.
So if the juvenile court trial was held in March of 2019, it was sometime before that?
Yes,
And was that in person or on the phone or what?
it was at court. She paged me to a courtroom where somehow she had discovered I was scheduled.
Okay, hold on. We don't want to know what she said to you because that's hearsay. But
I wasn't saying what she said.
Okay.
I was just saying how we came to have a conversation.
And that was at the juvenile court building during one of the trial dates.
Yes,
Okay. Were there any other times that you and Miss Apple spoke?
I don't think so.
Now, did you tell anyone else at CPS about the handprint?
I don't think so.
So the only person you talked to about there being a handprint on Gary Jr.'s face was Miss Apple.
The only person I recall telling about the handprint was Ms. Apple at CPS.
Was she the sole investigator of the case?
I thought she was. Well, excuse me, can I clarify that answer?
Certainly.
I know that there was a substitution of investigator, but I mean, one at a time. While she was the investigator, she was the only one.
So there was a substitution of investigators, correct?
Yes.
Do you know the name of the second investigator?
I could probably recall her last name if you give me just a second.
If I said it, would you recognize it?
Yes,
Was her name Juliet Todd Robinson?
yes.
Okay. Did you ever tell Juliet Todd Robinson that you saw a slap mark on your grandson's face?
I don't remember even talking to Ms. Todd Robinson.
So you did not tell her that there was a slap mark on your grandson's face. Is that fair to say?
Well, I don't remember talking to her. So if there's a possibility that I did talk to her, I just don't remember talking to her. And so I can't say what I would have said to her. So I don't
All right.
remember the conversation.
Okay, now we're moving on to a different topic. Did you complain to anyone that Miss Apple was biased in her investigation?
Yes,
Who did you complain to?
upper management at DHHS.
Who's
Mr. Baker, Ms. Her name will come to me in just a moment.
If I s-
McDougal,
Okay.
Ms. McDougal, and Ms. Ray.
Now, Mr. Baker is the,
And Mr. And I'm sorry, and Ms. Lynette Wright. They were all in a meeting that I attended with them.
Mr. Baker is the district manager, right?
Yes.
What role did Miss McDougal play? What was her title?
She was the section manager. Well, at least that's the way I know the name of the role. I think that the name has changed recently, but I'm not really certain what it's changed to.
And what about Miss Ray? What was her role? What was her title?
Ms. Ray was the county director. I know that she was head of the county child and family services, but I'm not certain of the exact title.
And what about the title of Miss Lynette Wright?
I'm not certain what her role was.
How did it come to be that you had a meeting with those four people?
Because I had a conversation first with Ms. Ray and then with Mr. Baker and Ms. McDougal. They were phone conversations. I believe that my conversation with Mr. Baker and Ms. McDougal was over the phone. I believe they were both in the same room together when I spoke to them over the phone. And I was invited to come and speak to them about my concerns.
Do you know when this conversation or this meeting happened?
I could check really quickly.
What would you be checking?
My notes,
Do you have the notes with you here today?
they're across the room.
Your Honor, could she have permission to go check her notes as to the date of the meeting?
Mr. Ashcraft, any objections?
I have no objection so long as this does not open up any other inquiry or request to see her notes.
Ms.
I
White?
was not planning to ask for her notes.
right.
Understood. No objection. Thank you.
Well,
Judge Green, do you want to go and look at your notes?
I will, but I may not need to. If Ms. Weingarten has a date in mind, I would definitely know it if she said it.
I don't have a date in mind.
Oh, thank you. May I, Your Honor?
Yes, please.
I'm sorry for the delay. October 22nd, 2018.
Okay, so how many meetings did you have with those people?
Just that one.
Was your complaint that Miss Apple was biased about her conduct toward you or toward your son, Gary Davis Head?
Well, it was specifically about me, certainly, but I really don't separate the two, because if she was biased towards my son, I've seen many instances where that bias bleeds into relatives. So I considered her bias towards my son bias towards me as well, because I was seeking placement of the children.
Was your complaint that you did not get custody of the children?
At that point, no, because they asked me if I wanted to have the boys removed from their mother and placed with me. And I told them, no, they're with their mother now. I'm only concerned about their safety, and I want you to investigate my concerns.
So what was it about Miss Apple's work that you considered to be biased?
Well, there's quite a bit. I can try to make it succinct. She, I'll try to summarize. She didn't report things that she knew would be disfavorable to Corey Bressler. And the reason why that's so important is because of the placement decision. I knew that the things that she was either not following up on that were complaints about Corey Bressler's mental health history, her history of violence, her history of violence towards her children specifically,
right.
etc.
Let me stop you for a moment. Are you aware that the reason Corey Bressler got custody of the boys was because she went into circuit court and got a court order granting her custody?
Yes, that's actually one of the instances that I used to complain about the bias, because Ms. Apple.
Hold on. Just answer the questions. So you're
Again,
aware.
Excuse me, objection, Judge?
What's the objection?
The question that was asked by Ms. Weingarten was, what about Ms. Apple's work did she consider to be biased? And she asked an open-ended question, and Judge Green is trying to fully respond to that question. And she's being cut off now, which is inappropriate.
Thank you. Response, if any.
Judge, my last question was whether she was aware that a circuit court judge allowed the children to go with Miss Bressler.
All right, thank you. Objection is overruled. Continue, please.
Thank you, Judge.
So you don't have any gripes about the fact that a circuit court judge granted Miss Bressler custody, do you?
I do, under the circumstances of this particular case, because he didn't know everything, and Ms. Apple made sure that he didn't. She colluded with Corey Bressler to hide the 3-year abandonment and the fact that she hadn't had any parenting time with the children, so that the circuit court judges who had given the parenting time order for Corey Bressler, who had been replaced, I should say, he left. It was Judge Kevin Cox, and he had a successor at the time that Corey Bressler obtained the change of custody order. And that judge did it ex parte, so he did not know anything about the case. He relied on, and the judges often do rely on, the CPS workers' support of the decision. She would not have received custody of those boys if CPS was not supporting that decision.
Do you have any reason to believe that Miss Apple was in court with Miss Bressler the day Miss Bressler and her lawyer got the custody order?
No, but I know that she was communicating with her and advising her through text and possibly email. I don't know specifically about the email, letting her know what she needed to do, how she needed to do it, etc. She was showing clear support for Ms. Bressler getting custody, even though she knew that Ms. Bressler had untreated mental illness allegations, violence allegations, and abandonment allegations. She didn't investigate any of those things, but supported Ms. Bressler in getting custody. So there's no explanation for that other than bias, as far as I was concerned.
Are you complaining that Judge Adele Harb, H-A-R-B, granted Ms. Bressler custody of the children?
Well, I'm not complaining that he did it, because the information that was provided to him was not full information.
And the person who provided him information was Ms. Bressler and her lawyer, correct?
With the assistance of Ms. Apple and Ms. Kavanaugh.
Well, you just testified that you have no evidence that Ms. Apple or Ms. Kavanaugh were present in Judge Harb's courtroom that day, correct?
That's correct.
And you have no evidence that Ms. Apple or Ms. Kavanaugh provided Judge Harb any information about this case whatsoever, correct?
Well, indirectly they did, because they told I shouldn't say they. Specifically, Ms. Apple told Ms. Bressler what she needed to do, and specifically told her if the judge needed any other information from her to contact Ms. Kavanaugh, and that Ms. Kavanaugh would assist her while she was at court.
So Ms. Apple and Ms. Kavanaugh were willing to talk to the judge if the judge wanted to talk to them. Is that what you're telling us?
Yes, I think so. That's a good way of putting it.
And to your knowledge, the judge never contacted either one of them. Is that fair to say?
Not to my knowledge, that's correct.
So I'm trying to understand why your gripe is with Ms. Apple when it was Judge Harb who granted custody of the children to Ms. Bressler.
Well, I could explain, and I think you would understand if I explained it, but it'll take a minute. May I?
Well, no, I'm going to move on. Do you
Okay.
still feel to this day that Ms. Apple is biased against you?
No, I don't feel that way. I know she is. I have absolutely no doubt in my mind.
After the children were placed with Ms. Bressler on June 28th of 2018, did you have any other contact with the boys up until the time Max moved out of his mother's house?
No,
Did you have any reason to believe the boys were being abused or neglected while in their mother's house prior to Max moving out?
yes, but nothing that was something that I had seen or known for certain. But you asked me if I had reason to be concerned about it, and yes, I absolutely did.
Did
I'm
you
sorry,
make
Judge Widgeon, some of the answer faded out at the end, and I'm going to need to have that repeated, please.
All right, thank you. Do you, Ms. Weingarten, want to have the question repeated and then allow for Judge Green to answer that?
Yes, please.
All right, Ms. Jorgensen, when you have a chance, please read that question to us.
One moment. Did you have any reason to believe the boys were being abused or being neglected while in their mother's house prior to Max moving out? I'm sorry.
Yes.
You may answer. All right, I'm sorry. I was probably speaking as you were trying to answer, but I was saying you may answer that question, and your answer is?
Thank you, Your Honor. Yes.
Did you have direct information about that, or did you have hearsay information about that?
I didn't have either about abuse or neglect happening at the hands of Ms. Bressler in her home. What I had was my knowledge about her violent history, her untreated mental illness, and the fact that she had abandoned the children for 3 years. So I was very concerned about their safety. And it turns out that my concerns were valid because she abused Gary, and she and her husband beat Gary up. He told you that himself. And he was in the mental health hospital himself after this incident where she and her husband attacked him. So I think that my concerns were absolutely valid. And I wasn't surprised, although I was very saddened by it.
We're moving on to another subject now. Were you ever a referee or a judge in the Wayne County Juvenile Court?
Yes,
Which were you, a referee or a judge?
Judge.
When did you become a judge there?
January 1st, 2019.
Before that, were you ever on a bench in the juvenile court in any other capacity?
No, ma'am.
When you were a lawyer, did you practice in the juvenile court?
Yes,
During the trial, the juvenile court trial in March of 2019, were you a witness in that case?
yes,
Were you under a sequestration order in that case?
yes.
Who was your son's lawyer at that time?
Brenda Richard.
Is Brenda Richard someone you know?
Yes,
Describe your relationship with Miss Richard.
she's a friend.
Were you ever law partners?
Yes,
For how long were you law partners?
well, let's see. We were law partners with one other person as well, and who is Corey Bressler's cousin, Christopher Flowers.
My
And
question, oh yeah.
I'm trying to remember when it was. Well, it would have been before 2009. So and this is just my best guess, Ms. Weingarten, but I believe that it was from maybe January or so 2017. I'm sorry, 2007 to July 2009.
So for approximately 2 years.
Yes,
And after you were no longer law partners, did you remain friends?
yes, and we were friends before we were law partners. We went to law school together.
Okay, I want to make sure Miss Jorgensen got that because you faded away. Okay,
I
have yes,
said we were,
friends before we were law partners, and we went to law school together.
yes,
are you still friends with Miss Richard?
yes,
Are you aware of what kind of law she practices?
yes,
What kind of law does she practice?
family law.
Is family law the same as juvenile protection law?
Well, it's a broad umbrella. It can include juvenile protection. It really just depends on who's using the descriptor. If you're asking whether she practiced juvenile law, I don't believe that she did, at least not on a regular basis.
Okay. How is it that she came to be your son's lawyer?
I asked her to represent him.
And she accepted?
Yes,
Were you aware that she had never handled a child protection case ever before?
yes,
Did she express to you that she was not certain she knew how to do a child protection case?
I don't think that she said that. I know that she certainly hadn't had a lot of experience with child protection, but I don't recall her ever saying that to me.
Did you assist her in preparing for the trial?
Yes,
How did you assist her?
I told her what direction to go in with certain investigative issues. I told her who witnesses were. I told her what laws she could use to support certain positions.
During the trial, were you in communication with Miss Richard about the trial?
No,
Did she call you during the trial to ask you for help or advice?
She may have, I don't remember specifically. And wait a minute, I'm sorry. When you say during the trial, do you mean during the trial proceeding, like that day, or do you mean during the period where the trial was going on? Because my answer to the first question depends on the distinction, so I may need to re-answer that.
Okay, I think you're fading away again. I just want to make sure we got that.
I did not get the very trail end because my answer, I may need to,
Modify the answer to the first question about whether I spoke to her during the trial, based on knowing what you mean by trial.
All right, so there was a juvenile court hearing held before Judge Brian Levy
Yes.
regarding the termination of parental rights involving your son. Is that true?
Yeah.
All right. So did you speak with Miss Richard while the case was being tried, but when she was not in the courtroom on the record?
Yes. I don't remember specifically when, but I'm sure that I did.
Did you talk to her during the evenings when trial had been during the day?
I think so. Yes.
Did you communicate with her by phone at those times?
Yes, that would have been how we communicated. Yes.
I'm sorry, I didn't hear the end.
One moment. I think the answer was yes, that would have been how we communicated. Is that correct, Judge Green?
Yes, ma'am.
Okay. Ms. Jorgensen, did you get the rest of that then?
I did. Thank you, Judge.
All right. It's just that at the end, sometimes the voice trails off. So we'll just, if that happens, we'll just make that correction. Thank you. Continue.
Did you also communicate with her by text while the trial was in progress, but not when she was on the record?
I don't remember if I did or not.
What about by email?
I think so. I think again, during the period that the case was being tried, which would have been over weeks. Yes.
And were you giving her assistance in her strategy and her involvement in trying the case?
Yes, to the extent that she asked me for it.
Did she reveal to you what information had already been given by other witnesses on the record?
She wouldn't do that.
So the
And
answer,
I did not ask her.
okay, so my question is, did she reveal to you what witness's testimony was?
No.
Was there a sequestration order in place at that trial?
Yes.
Do you believe that either you or she violated that sequestration order by your conversations with her about the case?
No, I don't believe that.
Did any law enforcement agency ever question you about your involvement in your son's juvenile court hearing?
No, but I'm not certain what you mean by involvement, but no law enforcement has ever spoken to me about the case.
Did the FBI ever question you about it?
No.
What kind of assistance did you give Miss Richard during the course of the trial, but not while she was on the record?
Well, there's no more assistance than that I could tell you about, additional to what I've already said. We talked about the case, and we talked in depth about the case.
And what advice or guidance did you give her?
I'm sorry, Ms. Weingarten, I can't be specific about it because there were multiple conversations. It was more than 3 years ago. We were even talking before she became my son's lawyer. So I don't remember specifics, but I admit that I assisted her. It certainly assisted her.
And did that assistance involve helping her draft questions and cross-examination questions for witnesses?
Yes,
Did it involve whether or not she should object to certain evidentiary issues?
I don't remember that specifically.
Did it involve helping her draft a closing argument?
I don't know. I don't know if I did that.
Did she reveal to you what the testimony had been?
No.
Getting back to the statement you made to CPS that I read to you 5 different times earlier today, you didn't say that answer in your request for comment answer, did you?
In my what?
Okay, so we sent you a letter asking for your comments. Is that correct?
The 28-day letter? Yes.
No,
I mean,
so
is that what you mean?
let's go back. So the first letter you received was simply called a request for comment letter that you answered. Do you recall that?
The very first letter?
Correct.
Yes.
Okay. You remember answering that letter?
Not specifically. I know that I did.
And you did that under oath, correct?
Yes.
And you signed it under penalty of perjury, correct?
Yes.
In that request for comment answer, you did not say that you told CPS you put makeup on the handprint on Gary Jr.'s face, correct?
I don't think that I did. And the reason why I'm saying I don't think that I did is because I haven't looked at that.
You also
Lately.
answered, okay. You also answered a document called a 28-day letter, correct?
Yes.
In your response to the 28-day letter, you did not say that you put makeup on the handprint on Gary Jr.'s face, correct?
Correct.
Have you read through the 5 protective services reports that we now have?
At one point or another, yes. But
Is it-
the first 2, it would have been quite a while ago.
Would you agree that in total, there are 106 pages of those reports single-spaced?
No, I can't agree to that. I'm sorry.
Foundation.
Okay, well, can you agree that 2 of the
One-
pages?
One moment. The objection is for foundation. Ms. Weingarten, are you responding to that at this point with your question?
I'm asking, can I lay a foundation?
Yes, you may.
Judge Green, are you aware that 2 of the reports were 10 pages each, but that they were duplicates of each other?
2 of which report?
The CPS reports with the signature date 9/18/18 and 10/4/18.
I'm sorry. Ask the question again, please.
Okay, you're fading out.
Will you ask the question again, please?
Judge,
Can you hear me?
Yes, I can hear you. Judge, do we want to make sure Ms. Jorgensen got that?
Ms. Jorgensen, did you get the last question and answer?
The CPS reports with the significant date 9/18/18 and 10/4/18.
So that was my question, but I don't think she got Judge Green's answer.
Oh, I'm sorry. I thought it was to read the question back. Judge Green asked, I'm sorry, ask that question again.
Okay. May I ask that question again, Judge?
Yes,
Are you aware that there are 2 CPS reports with a complaint date of August 6th of 18 and signature dates of 9/18/18 and 10/4/18, and that they're each 10 pages long and they are duplicates of each other?
I'd have to say no, that I don't know that. That's why I'm taking as long with my answer that as I am. But if I can elaborate, may I?
Yes, please.
So There are technically only two CPS reports. The one from the complaint for June 24th, 2018, and the one from the complaint for August 6th, 2018. But there were multiple versions of each of those reports. And that's why I'm not certain what you mean by the two, there being two 10-page August 6th reports that were duplicates. I don't know if you mean they were carbon copy duplicates or if you mean that they were a different version of the same report.
Okay, well, let's do it this way. Is it fair to say that there are multiple reports that are single spaced and add up to a lot of pages?
Yes. Yes.
In any of those reports, you don't see a statement where you told Miss Apple or anyone from CPS that you put makeup on a handprint on Gary Jr.'s face, correct?
Judge, objection.
What is the objection?
The CPS reports are not in the record, and they have not been allowed to be in the record. And now a question is being framed and asked based upon the content of the CPS reports. Those have not been admitted into evidence.
Response, if any, Ms. Weingarten.
I don't think that makes this an improper question. She's read the report. She can say that her statement does not appear in any of them.
Mr. Ashcraft, do you still have the objection?
I do, Judge, for the same reason.
All right. So I will sustain the objection. Ms. Weingarten, would you like to make a separate record?
Yes, please.
All right, thank you. At this time, then, Ms. Jorgensen, we're going to ask you to make a separate record. What we will do at this time is go into one of the sidebar rooms and have you do that, and then we will come back into this main hearing room once we have concluded with that portion. So let's plan to do that. All right, let us continue then with your next question, Ms. Weingarten.
Ms. Weingarten, you're muted.
Okay, thank you. All right, Judge Green, can you hear me?
Yes.
Okay, I am told I left something out of a series of questions I asked you before we went on the separate record, so I'm going to ask you a different question about the same topic. You remember we were talking about your answer to our request for comment letter that you answered under oath?
Yes.
My question about that is, did you say in your answer to request for comment that you told CPS that you put makeup on a handprint on Gary Jr.'s face?
Yes.
You believe you said that in your answer to request for comment?
One moment, please. Judge Green, your voice is going low. So if you could keep it up a little louder. All right, so your answer to the last question was?
Yes.
Thank you. Continue.
You believe you answered that in your answer to request for comment, that you told CPS that you put makeup on a handprint?
It's, the objection I have, Judge, is the question is ambiguous. We've been using different language to describe different documents. If I may, Ms. Weingarten, just indicate to you that the first letter that was received by Judge Green has always been identified as request first to respond to a first set of questions. Then there was a second letter that was a request for response to a second set of questions. Then there was the 28-day letter response. Then there was the answer to the complaint. So that's the way that we've handled that and have been communicating about it. So when you're making reference to it as, I even forget what you're referring to it as, I'm not so sure that that's understood in terms of what document we're talking about. So.
Okay, thank you, Mr. Ashcraft, for clarifying that. I can rephrase the question.
Thank you.
Okay, Judge Green, apparently you and your counsel have referred to what we call an answer to requests for comments as a first set of questions. So my question to you is, in your answer to the first set of questions, did you write that you told CPS that you put makeup on a handprint on Gary Jr.'s face?
No.
In the answers to your second set of questions, did you write that you put makeup on a handprint on, and you told CPS this, on Gary Jr.'s face?
No.
In your answer to the 28-day letter, did you answer that you told CPS you put makeup on a handprint on Gary Jr.'s face?
That I did tell CPS that I put makeup on a handprint?
Okay, so let me rephrase the question so that we're clear. In your answer to the 28-day letter.
I just couldn't hear you. I'm sorry. I just want to be sure.
Okay, so I'll say it again. So in your answer to the 28-day letter, did you ever say that you told CPS that you put makeup on a handprint on Gary Jr.'s face?
I know I said that, but I'm not sure if it was the 28-day letter or the last response.
Is it fair to say that you're in the answer to the complaint was the first time you made that statement?
I think so, but I know I only made the statement once. I'm just not certain whether it was the 28-day letter or the last response.
Judge, could I ask Mr. Ashcraft if he would stipulate that she did not say that in her 28-day response, but did say it in the answer to the complaint?
Mr. Ashcraft, any response?
Judge, I just don't have a copy of it in front of me, but if it's not in there, then I will most certainly agree with Ms. Weingarten and we can submit that as a stipulation. But I do, in terms of being prudent, I want to make sure that I confirm that.
Okay.
But if that is accurate, we will so stipulate.
All right, thank you. Continue.
May I have a moment with Mr. Helen to make sure I did not forget anything?
Certainly.
I'm back, Judge.
Yes.
We have no other questions of Judge Green.
All right, thank you. Mr. Ashcraft, questions at this time?
But not at this time, Your Honor. I'll reserve my right to direct examine Judge Green during the course of our proofs.
All right, thank you. Ms. Weingarten, any additional witnesses today?
No, but I did have a conversation or a text from Attorney General Drysdale Crown. Apparently, Mr. Baker is not available on September 24th, but he would be available on the 27th.
All right, we can have this discussion after we're done with the live streaming.
Oh.
No additional witnesses today?
Correct.
Thank you. Mr. Ashcraft, anything that you would like to place on the record before we end for today and have our separate discussions?
Nothing, Your Honor, until we have our separate discussion. Thank you.
All right, thank you. This will end our live streaming for today. We are scheduled to come back on, we had initially scheduled our return date for the, looking at my calendar now, I believe for the 22nd, but it is our understanding at this time that we will not be coming back on the 22nd, and therefore there will be an order to that effect. Counsel, am I correct in that?
Yes.
All right. All right, so at this, Mr. Ashcraft, do you agree?
Yes, I agree. Thank you, Judge.
Thank you. So at this time, we will close the hearing for today, and